and welcome to your onboarding of your estate plan. If you don't know me, my name is Scott Royal Smith. I'm the owner of Royal Legal Solutions. I'm an asset protection attorney. I also focus on tax, estate planning, and all the legal matters that result as a need for real estate investors. Today, we're going to be going through your estate plan with Gina Folk, which is our COO. We're first going to start with a brief reminder about what are the key terminology and how do the estate plan work structurally and the overall asset protection operational structure that you're putting in place as the foundations. And then we're also going to go through and walk through the questionnaires that are needed to be able to get the basic information to be able to produce that estate plan for you. So today, Gina is going to be posing as a client, and I've instructed her to say, hey, Gina, act like you don't know anything. So I could do great explanations for everybody for any of the top questions that we might have here. So as we go through the process here today, please let us know what additional clarifications are going to be helpful to being able to make sure that we have a successful support for you in answering any of these questions. So I'll go ahead and kick us off, guys, with just as a brief reminder as about what is this estate planning and how does it work as part of our overall structure. So when we look at estate planning, the first thing we look at is our structural pieces. So you guys remember we have our asset holding company because we're going to act like rich people do, and we're not going to own anything anymore, but our asset holding company is going to own everything. We're going to own that company and all of the assets anonymously underneath this section of the company structure. Then we're going to have an operating company, which helps protect us personally from lawsuits and also potentially gives us some tax advantages and also access to be able to use some of those retirement accounts. And then here's the critical piece that we're talking about here today. It's this living trust and all of the other estate planning documents that come into play here. So remember that as in terms of structurally, where does this stuff sit? Everything flows up into the living trust, and ultimately the living trust owns everything in your life. Here is our most important terminology about what are all of the individual components that we'll be completing as part of the estate plan. We have the pour over will in the living trust. We have the declaration of guardian. This is where you appoint who can be a guardian of you or your children and result of incapacity or death. You have your living will, which is how do you want life-saving procedures to go if you're ever hospitalized. HIPAA authorization allows your medical power of attorney to be able to have the healthcare information they need so that the medical power of attorney can make those crucial medical decisions for you per your guidance. And then a durable power of attorney that is allowed to be able to handle your financial matters to a limited extent, just to be able to make sure that while you're in the hospital, that you're still collecting rents, paying your mortgages, paying your insurance, those critical financial needs for us. That could because we're not dead yet, and the pour over will and the living trust come into place. We're still alive, so we need somebody else to be able to help us. And that help comes from these durable power of attorneys and the medical power of attorney. Just a brief refresher here on our pour over will versus our living trust. Your living trust will ultimately own your company structures, your operating company and your asset holding company. That ultimately means that it owns all of your assets. And this living trust, what it's going to do, it's going to help avoid probate, which is going to keep all of your assets anonymous, including the extent of those assets and who is going to inherit them. It also makes sure that the assets get passed to your beneficiaries and doesn't get taken or decided about what happens with the government, and allows you to be able to control the process even after your death. What is going to happen with all of my assets after I die? Now, we might find that not everything goes into the living trust, right? Maybe your watches, your shirts, other things that are like, hey, that's not really appropriate to put into an asset holding company and go through all that effort. Well, what do we do with those? Well, that's where your pour over will comes into place to say, let's take everything that happens inside of your pour over, anything else that's there, right, that we haven't put into the living trust of the asset holding company, and let's push it into the living trust. And then we'll distribute those assets in the way that the living trust says to do it. So this is the piece that we control during our life. That's the living trust. And our pour over will is kind of like our catch-all for anything we forgot, or we just said, hey, it's not worth the effort to retitle that inside of the living trust. Next, we're going to look at our are different types of powers of attorney and authorization. So one here is our HIPAA authorization, which is getting all the medical information that's needed for your healthcare power of attorney to make those decisions for you. And then ultimately your durable power of attorney is what we'll be spelling out who can make those limited financial decisions for you to make sure that your finances stay in proper order while you're hospitalized or otherwise incapacitated. So lastly, guys, we will now be turning over the microphone to Gina Folk as she will be demonstrating for you guys what is the journey for you in filling out your questionnaire. So Gina, we'll turn it over to you.
Okay, so my first question, Scott, is where are my questionnaires? How would I get my questionnaires? Where are they?
Yeah, so your questionnaires should be sent to you via email. That'll have the questionnaires for the estate plan, but also for anything else that you've decided to put in place now. Should all be located inside of an onboarding email. If you want, you can have that email up, Gina, that I sent you. Are you able to pull that up and walk us through what that looks like?
Yes. So this is the email you're talking about where it's kind of got it just says, here's questionnaires. I guess this is it, right? Yes.
Yeah.
So this email I just went to the email that I had given to my salesperson. So that makes sense. So I see we're going to talk about estate plan. Oh, cool. There's a little link right here. I'm going to click it and see what happens. Oh, look, there's the questionnaire. There we go. I presume this is a questionnaire, right?
This is the questionnaire for estate planning that we will
great.
So all we have to do is fill this out. So you can see that this is up at the very top, that it's to your account. And so let's just go ahead and put in your email information. And for any other information that we have in here too, we'll just put in dummy info as well.
Okay.
So we have our email. Then we'll also need your legal name. So that'll be like the name that you'll end up going by for any of your government identification.
Now I'm putting my name in here, but I also bought asset protection. This is just for y'all's use, right? Nobody's going to see all this.
Right. So this is just going to be for the private documentation regarding what you need to be able to have for the internal documentation. Anything that we put in place that goes onto the public record, we'll always be thinking about how to screen that information.
Okay, so some of this stuff I get, this stuff's easy. I'm just putting in my date of birth, gender, phone number. Just put in my. Okay.
So also, this is your home address. This is how we're able to identify what your address is we're locating into, is that people will look at this living trust document and they'll say, well, how do we know which Gina Folk this actually relates to, right? So, well, it's the Gina Folk that's resided at this address in the past. That's how we can make sure that we know which of all of the Gina Folks in the land, which ones would be the appropriate one that this relates to.
All right.
Yeah, so that'll just be your typical address with street, state, city, etc. Same thing here too. So if this is the same address, your home address is the same place that you want to receive mail, then you can go ahead and just leave this one blank.
I think I have to fill it in, but I can just cut and paste.
Okay, cool.
Because I think that little star.
Look at that. It has a star.
Look, so it has a star.
Have filled in. That's
right.
I'll
just cut and paste. Okay, I got that stuff done. That part's easy. Now, what is woo, look at all this. I don't even know what some of these words mean.
Yeah. So looking at this, where we look at whenever we're doing our living trust, our living trust documentation will refer to a beneficiary. In this case, the beneficiary of that living trust is who is going to inherit whenever you die, right? So beneficiaries can be your children, can be your parents, could be charities that you care about. And here what we're looking for is information regarding at least one beneficiary. So Gina, if we have just one beneficiary that we were going to list, and you say, hey, I'm going to leave it all to everybody to have an example of what a complete beneficiary looks like. We're looking for their full name, date of birth, phone number, and address of who that could be to be able to inherit on those assets. So the full name is important, right? Because that's who the person is. Then we need the date of birth of that person to make sure, hey, do we have the right Kevin, right? We need the Kevin that's born on this date, because that's who the beneficiary of that's going to be. Ultimately, that's the trustee of your trust. The person that controls your trust after you die is in charge with making sure that it's this beneficiary is the one that receives whatever they're supposed to receive. So that trustee, whoever you appoint to do that, is going to then look for a Kevin that as at that date of birth, and we're going to give them a hint about how to find that person, because we're going to leave them the telephone and address of that person so they can know how to get in connection with them. And then we also want to know, like, what is the relationship to you? So that way that they can better identify that they have exactly the right person in that context. And so in this case, what we would do is if you had 5 people, right, and you had a charity, you would do the same thing with each person or charity as like, hey, give us all the complete information about who that person is. And here's the information, the additional information we need about how to identify that we have the right person or the right charity. That's where all that other information comes into play.
Okay. So if I have multiple people, I just keep typing, and but at this point I just have one.
Yeah. If you have just Kevin, and the next person could be like Jessica Reyes, and she's born on this date with this phone number, this street address, and that she's my friend,
okay,
whatever that.
And what happens if I want to add more? Like if I fill this in now and I want to add more, is that a big deal?
Yeah, what's great about the way that these living trusts work is that you don't have to get it perfect. You just have to get it done. So at any time that we want to amend these trusts, we can. It's just some simple paperwork, a simple amendments we're able to do. And then we notarize some documentation, renotarize the documentation, and then we'll be able to do the amendment of the trust. Typically for us, as part of, if you're a Peace of Mind member, we're reviewing that with you on at least a twice yearly basis to say, hey, is everything in here the way that we want? Have we transferred all the assets into this trust or inside of the entities that underlie this trust, like your asset holding company? And by the way, are these still the beneficiaries that you want, and into the proportion of what you want those beneficiaries to have, right?
Okay, so I don't have to get this perfect right now. I can just do what I know at the moment, and we can always adjust as I need to. Great.
That's right.
Okay, great. Okay, so here's another question.
Yeah, so this question is looking up back at the beneficiaries, right?
Yeah.
Do they qualify for government assistance due to special needs? What we're trying to figure out there is saying, like, are any of these beneficiaries special in the sense that they're actually going to need like a special needs trust? They're not in the same position as a normal beneficiary that has the capabilities of handling all of these affairs otherwise, that we need to create some type of special assistance for them. So we have in there that's like SSDI or Medicaid. That would be indicate to us to say, hey, these are going to be issues that we're going to make sure that the beneficiaries are going to inherit in a way that's going to be supportive for them, giving who they are and what their capabilities are. So, and if this case is if you say, hey, I don't have anybody that meets those needs into it, that have like a special needs type of person in my life, then we can go ahead and click no to that, and we'll be able to move to the next section.
Yeah, so right now I'll just click no, I don't have that at this moment. So
great. So before we talked about beneficiaries, right? And now here you can see in this question, we're talking about specific bequests. So beneficiaries are the people that are going to inherit, right? The trustee is the person that's in charge of making sure that the people that are supposed to inherit, your beneficiaries, actually inherit and get what they're supposed to get. A specific bequest is there anything specifically that you have that you want a specific beneficiary to take, right? Like, I want my son to have my grandfather's watch, right? Would be like an example of that. Or I want this person to have this particular piece of property. Otherwise, what happens is that there's general division among the beneficiaries. So generally speaking, beneficiaries take a percentage of whatever it is inside of the trust. They become joint owners of that trust, unless there's a specific bequest. So if you want your son to have your grandfather's watch, you want that to spell out here. Otherwise, all of the beneficiaries share in the ownership of grandfather's watch. Right?
Okay. Yeah. So I have a question on that one. So if I had multiple beneficiaries, so like if I had 2 or 3, would it be equally divided, or would I need to put that in my beneficiary request?
The default, unless you list percentages, is that it will be an equal division amongst all the beneficiaries. If you want specific beneficiaries to have a specific percentage, then we need to spell out what that percentage is going to be. Just like when we talk about specific bequests, right?
Okay.
It's going to be individualized. Then we need to have that place to spell out that it's going to be individualized. Now, importantly, a specific bequest doesn't have to be made to one of your general beneficiaries. You might say, hey, I want everything divided to my children, and I want it to all go in equal shares, except for my comic books. I want my comic books to go to my buddy Roy, because we were comic book nerds together. I know he'll really appreciate these comic books, and my kids could care less about them. So I want them to go, over to Roy. Roy is not a beneficiary in the common sense that he's going to take a percentage ownership in terms of of your estate. But he's going to get that one particular thing. I always recommend for people that the specific bequest is a great thing to do, and to do it in a way that gives a little something to the people in your life that lets them know hey, you thought about me during your life after death, right? So even if it's just a small thing that is sentimental, think about it in some type of morbid form of Christmas. It's hey, I got something out of there. They cared enough about me to think about me as part of their estate. And that means a lot to me now. And that's kind of typically is the use of a specific bequest here. So I see you here, Finn. It's you listed the person's name, the address, so we know who that person is going to be. And then also the amounts to be given, which is particularly the diamond ring and $5,000. Now So that's perfect. I think that's exactly what we're looking for here is what's going to be the identifying information around that person and what exactly you want that to be.
And I can make the list as long as I wanted to.
Yeah, you can have as many people, and you can add to this list as you go to on that twice yearly basis that we meet with you into it. You can actually modify it as many times as you want, but that's our process to hold accountability, say, hey, we're going to make sure that we're at least looking at this twice a year to make sure that this is cleaned up and taken care of. Because accidents and death can happen at any time, right? So let's just stay on top of it in a really light touch way to be able to make sure that we have things cleaned up.
Okay, awesome. All right, what's next? Looks like funeral arrangements.
Funeral. Oh man.
Do we have to talk about the funeral arrangements?
Got to talk about funeral arrangements. Otherwise, we don't know. People don't know what to do with you. We go into it. So what do we do? So the question becomes what do we want to do? My personal funeral arrangements is a Viking funeral. I was put me in a boat and somehow shoot a flaming arrow into it that ignites in an inferno on the lake.
Yes, that's what I want too. Is that legal? Can we do that? I mean, I guess we should put something that's legal in here, but
it might be a little bit illegal to do that, but so typically we just try to stay inside of the bounds of what's legal and normal, and not give everybody what the heck are you talking about here, Scott, that you wanted us to do? Just leaving us problems we have to solve. Well, that's typically going to be either your cremation or a typical burial or anything that's really important to you about those funeral arrangements. The issue here too, as you come into burial, is that you want to be able to spell this out for people, because otherwise they're left with having to decide what it is, right? So if you want a creation and a kegger, you want to have an Irish funeral, awesome. Spell out what that is. That way you can be this is what I want my end of life experience to be like for all the people that are there into it, right? So that's really what it's about, right? It's about what are your wishes that's important to you about that, and also thinking through hey, how can I help provide guidance to everybody's there, so that way they don't have to guess on what your wishes may have been around your funeral arrangements. Most important thing though is that you just get something, because we can always modify it as we go in the future months and years as you get more clarity about, hey, what's going to be important to me about that. So don't get caught up on it. Just put something in there that as generalized here, I want a cremation, a party, I want music, I don't want anything sad, and take me and spread me in my favorite places. Awesome. Perfect.
Awesome. All right.
Life support during pregnancy.
But if I were pregnant, it would be important.
What if you were pregnant? Well, that's not an issue for me. So I would probably put I was not applicable into it, right? And so this is a place where you have to decide, is saying, is this going to be important to you? So if it's not something that's important to you, then just put not applicable. If it is something that's important to you, then you'll want to spell that out here, right? Which is what are your other options that exist? And we want to make sure that we have that for any medical directives that are there as part of our documentation.
Okay. Yeah. And this one, if I were in that realm of being pregnant or thinking I was going to be pregnant, because this doesn't just have to be if you're pregnant right now. It's like if you think you're going to be pregnant in the imminent future, right?
Yeah, or just really like at any time, right?
At
It's
any
like
time.
pregnancy on the table of things that can happen.
Right. Yeah. Anything's within the realm of possibility, right? So
Right.
just
Right,
really
yeah.
consider what that would mean. Because if you say not applicable, what's going to happen? Somebody else is going to make that choice for you, right? So if for whatever reason that happens, like somebody else is going to make that choice.
That's right. The choice has to get made, but here they won't have direction on what choice that you would want to have made if that happens, you know?
Great.
So
Okay. Awesome.
cool.
All right.
So this is where we get into how medical decisions will get made, right? So if you're already married, your spouse is already the primary person. It's called the primary agent, right? An agent in this circumstance is just a person that represents you, right? Or represents your interests into it. So if you're married, that's already going to be yourself or be your spouse. If you're single or have any other preferences outside of it being your spouse, as a default, then we need to be able to say, okay, who should we list here to make decisions for you? So we ask as part of our initial question here is like name 2 people to make medical decisions for you if you're unable to do so, like you're hospitalized. Now, the reality here is we ask for 2 because what happens if we can't get a hold of 1? But remember, we're also saying if we don't know 2 off the top of our head, we're also saying, well, 1 is better than 2 because having 1 and having the document completed is much more important than having it perfect, because we can always go back and amend and add 2 people, 3 people, 10 people if we wanted to. It doesn't, all of those possibilities are there. So for right now, let's just put in 1 person, because we only maybe know 1 person that we would say, hey, I know there's this 1 person that I would trust to be able to make those medical decisions for me. They seem reasonable. They're in line with my thinking about like what are appropriate, types of medical decisions that I would want to have in that circumstance. So I think we went down to financial decisions. I think you're 1 field up here.
Oh, I'm 1 field too far.
Yeah,
Yep.
1 field too far. Got a little ahead of us.
Look at that.
So, but it could be like just that, like a quick copy paste job, right? And say, hey, it's still just Kevin. Kevin's my person, whether it's going to be medical decisions. Now we come down here for the financial decisions. This is the same kind of place here too, right? We're asking for 2 people, but if you have 1, just list 1. You might find that like, hey, I trust this person for medical and this person for financial, because the person that's like really in line with me on the medical side of what's important to me is not a money person. And I want my money person, my detailed oriented, type A, money person in my life to make the financial decisions for me. If it's the same person, great. This is a quick copy paste kind of thing.
And when you're talking about financial decisions, is that just anything that has to do with the money, like money where? I mean, what kind of financial decisions?
Yeah, so we're looking as to be able to make it where they can make financial decisions for you that are critical to the upkeep and maintenance of your portfolio, right? Or of your finances, right? So that's like collecting rents, paying insurance, paying the mortgages, those critical things that if they weren't taken care of would have drastic and negative financial decisions, or negative and drastic financial consequences to you. What they're not going to be able to do is make all of your financial decisions, right? So they'll be restricted on their ability to buy and sell assets, right? For example, is one thing, because they know we don't want them to be able to like start retrading my stock portfolio. I just need them to make sure that these things are taken care of and maintained, right? So the idea here is how do we just maintain things while you're incapacitated, and they're limited in what they can do to not actually fundamentally change anything with your finances.
Yeah. Okay. And so I just need to make sure that, I'm putting these names in right now because it's what comes to top of mind, but really, really go back and, for the form, it's fine. But if I change thinking, oh, wait, this person maybe is not aligned with me on finances or they're not good at it, I can come back in and change it.
Yeah. At any time we're able to do an amendment for it. So if you're like, oh,
great.
Man, that person picked up a drug habit, I need to change that right away. Fantastic. Get a hold of us and we'll go ahead and re-execute that right away, because you don't want that part in your life. So what might work well really right now might not work in the future. That's the way life goes, right? And so the process to change that is very streamlined and straightforward.
Okay, great. Got it. Thank you.
Cool. Great. So here we're coming in we just did the healthcare power of attorney and durable power of attorney. That's what has to do with the medical decisions and the financial decisions. That's our critical information there. That's up here at the top.
So
Now,
this is for the medical power of attorney.
Yeah, this
and this
medical
is for
power
the durable.
That's right.
Okay.
Medical power of attorney relates to medical decisions. Durable power of attorney relates to financial decisions.
Okay.
Lastly, here is what we have, or not lastly, but next what we have is coming up as where we're talking about, you can see here, it's our will and our living trust. These are the two most critical documents because that's where happens with all of our assets, all of our stuff when we die. So when you have a will, if you're legally married, typically each spouse will serve as the representative of the person's estate. That's the person that manages the fare of whatever is included under the will. Remember, the will is only going to treat things that haven't been put inside of the trust. So whoever's going to do this for you, their job is really just to ascertain what's not inside of the trust and move it into the trust. That's the only thing they're going to be doing. So you are able to designate this to either be your spouse or it could be anybody that you wish. Again, we ask for 2 people, but we need a minimum of 1 to be able to complete the estate plan. So if that's whoever that might be in your life, to be able to list as your personal representative of your estate.
And you
you'll
just need
also
their
hear
name.
this is referred to as like an executor of an estate.
Okay, executor. I've heard that term before. So, okay. All right. So just put in the address.
Yeah. So here we'll just do like the name, address, and phone number for your personal representative, or also known as your executor of your estate, in terms of what happens with your will.
And in here, it says something like in the order you want them to serve. So do I need to put like 1, or is it just going to be the order I type it, or does it matter?
We're going to assume that the first person you list is number 1. The second person you list is always number 2. It's always a primary, secondary. The 2 people that you'd ever be listing here don't serve in a dual control capacity. The first person listed will have primary control, and it's only if they're unavailable or otherwise incapacitated in one way or another that we say, great, well, let's go to our alternate in that sense. So here that would be like Chuck Frank would be number 1 because they're listed first, and then Jack would be number 2.
Okay, great.
Great. So now we're coming in to our living trust. As we go through our living trust document here, the trust is what's going to own everything in your life, right? It's going to own all of your companies and be the ultimate owner of all of your assets. When we talk about the trustee of a living trust, that's the person that's going to be responsible for administering, making sure that whatever the trust assets are go to the beneficiaries, right? They're the ones that say, great, that watch actually got delivered to son, right? From grandpa's watch actually got delivered to son. That's your trustee's job there, right? So here, the default is typically to have your spouse listed as that trustee, this is your representative. It's your primary trustee of your living trust. However, the same type of analysis that we did above also applies here, right? Be your spouse, or it could be anybody. So it's whoever you want to be that responsible person to making sure all of the assets flow to the beneficiaries in the right way.
Is it confusing if it's different people? Like if this the personal representative that does the will is different than the person that does the living trust? Does that not get confusing?
It won't be confusing. Typically it's the same person, because most people have like, cool, I have this is the most responsible person in my life, or the 2 most responsible people in my life. I want them dealing with all of the assets. And so typically whatever you list for your will is also listed for your living trust. They're 2 separate functions though. The personal representative inside of the will is a person that's dealing with the court, right? And dealing with this process of how do we move the assets into the trust. The person that's listed as a trustee is responsible for, like, now that everything is inside of the trust, how do we distribute those assets out appropriately to the beneficiaries?
Okay. All right. I'll just make them the same people just to make it easy.
Yeah, I think it's typically easier just to have the same people there, unless there's really good reasons to think why you would want one in one circumstance and not in the other. Great. So here, this is where we have a question about whether it's going to be a joint living trust. So if it's just you as an individual and you're not married, or you are married, but you have different sets of assets that you want treated separately, and they're individual assets. They're not part of your marital assets. This is where you would have an individual trust. It's either because you have individual assets separate from your married assets, or you are just an individual. That's going to be an individual living trust. You do a joint living trust in the circumstance that you are married and you want both people to be together, both spouses inside, encapsulate all of the assets as these are all of our assets together, and this is how we want all of our assets to flow.
Okay, I have to ask this question. So what if I have what if I'm not legally married, but I've been, partnered with somebody for a long time? It has to be legal marriage?
No, it doesn't. Any
Okay.
two people can actually have a joint living trust together. What'll happen though is, remember, this joint living trust, it's the ultimate owner of all of the assets, right? So if we're going to say it's husband and wives, typically we'll say like, oh, well, honey, everything is ours. So we just need one vehicle, one living trust to control everything for us. And if you're like, well, you're not married, but you want to do that, awesome. But just remember, it's the same exact thing as if you were married. Now everything becomes both of yours. So even though you might not be married, you're married in your finances.
Okay, we'll do individual right now.
Okay. Next question is are you legally married? So that will be no. In this case, that will just allow us to be able to key off any other things here. So this last form that we have here is any additional questions or comments. So that way we can key off anything in the team of like any confusion that you may have had at the time. Otherwise, just put no or nothing right now. It's going to be that place to be able to give us that direct feedback. So when we review your form, it'll key us off of like, oh, I need to talk to Gina about XYZ area. It helps me focus my attention of what's going to be the best support that I can give Gina after she clicks next. So go ahead and click next, Gina. Cool. Okay. So this comes into your estate planning as it relates to the children. So does a client or legal spouse have children to include in the estate plan? So great. So yeah, if the answer to that is yes, you can simply click yes or no. And so now this is where we need to ask the questions regarding the children. So here, if we have an individual living trust, and so we need to specify if the legal name of the child, their date of birth, and then we also need to specify who, if you're married, right, then it's like, who does this child belong to?
Names and date of birth, just names and date of birth. Okay.
Yeah, full names and date of birth. And we're going to list, who does the child belong to?
So I'm going to say in this case, because there's not a husband or a wife, I'll just say Gina.
Yeah, Gogs of Gina. Right, there you go. That's my kid. This is the children. So now if the child is under the age of 18, there has to be somebody who's specified to say like, who is going to take care of this child. Now, as a standard practice, all of the assets that goes to this person that we call the guardian, who's responsible for taking care of the child, is restricted to only using the assets for the upkeep and maintenance of the child. It's for the child's benefit, right? They're a custodian essentially of taking care of the child and taking care of the assets of the child to make sure those are used appropriately for the care of the child. So here, that's going to be who. Say, you get into that car accident or whatever, who do you want to take care of the kid that you think can take care of the kid right and make sure that they're being a proper custodian of the assets for the benefit of the child?
Mine's not under 18 right now, so we're good.
Okay, so we'll have, if it's no children under 18, then you can leave that blank. Otherwise, I'd be like, hey, that's my sister. This is where she lives. This is her phone number. And you might want to list more than one guardian if that's important to you. Otherwise, we can go back and add that as we go. Great. So now we have trust distributions. So here's what we talked about before when we were saying like, hey, well, I have all these different beneficiaries, right? And maybe those beneficiaries are for most people are typically their children. Here is a place in our process where we say, well, great. I either want you to just distribute it equally among all of my children, since they're all beneficiaries here, or I want to do it in some other way. Right? Which would be, I want to be able to control the amount that's distributed and when they get it, right? Some people would say, Well, I want to make sure this is a lot of money, right, that I have here. I believe in a lot of money, and I want to separate this in stages. I know that I want to give so much to them at the age of 25, so much to them at 30, and so much to them at 35 when they're a little bit more mature. So I can give them some of the money while they're younger, but I'm gonna wait until they're older to have them get all of the money, because that much money for a 25-year-old is not a good idea. So this is where you would go through and think through about, hey, do I need to think about whether my kids are going to be getting different amounts and when they're going to inherit that. As a good default, if you're not sure about the specificity, is to just say, let's distribute the assets equally. That's a standard good default. We distribute the assets equally at the ages we have specified above. That's our typical best practice. A quarter of the assets at 25, one half of the remaining assets at 30, and then at 35, they get everything that would come into it, that the full remainder would be. So most of our clients will actually distribute the assets equally and use that as a distribution model at 25, 30, and 35.
Okay, great. Sounds good to me.
All right, so what could happen, right, is that all of the beneficiaries that you would ever have and your children, there are, that you survived them, right? Meaning that, wow, all these beneficiaries, they're no longer. So in that case, if you have no children, or all the beneficiaries otherwise are no longer living, what do you want to do, right? Where do you want this to go to next? Well, it could be either like grandchildren, or this could be brothers and sisters. It could be charities that you care about. And in this case too, would be the same type of question. Who do you want that to go to? What's the identifying information that we would need to know exactly who that person is? And what is the percentage or specific amounts that you want distributed to that person or to that entity? As a default here, just to let you know that if you don't have any of those things as top of mind for you, a default could be is just to leave this blank, which just means, great, what the trustee is going to do at that time is just look at who are the living heirs that you have, right? And first say, great, do I have any children or grandchildren? And first goes down to them. Then it's going to go up to grandparents or parents that are still surviving you. And then it goes sideways to your brothers and sisters, right? As a default.
Okay, so because this is, I think this little thing means it's required. So I could just put in, don't know, and it'll do it. It'll do it in its natural order.
Right. Exactly. Right.
Okay.
Yeah.
Okay. So, all right. What does this say? Royal, where you can.
Yeah. So this is our disclaimer here for Royal Legal Solutions, right? That says we can't actually do anything until we get the information from you, right? So here's what we're asking for you to do is that you'll agree to complete your questionnaires within 30 days so that we can keep with the delivery timelines that we told you initially. That's like, how long is it going to take for us to be able to complete this project? Additionally, we have a 14-day window for anybody that is asking to say like, hey, I've changed my mind, or some like, hey, I lost my job. I actually need like a refund on it. Great. Well, what's our window to be able to work with people in the right way there? So what we've done is we've created a 14-day refund policy for us. So that way we don't spend too much of our time into it before we're fully committed to the project, right? So we believe that the right fit for that is about 14 days. That says this is the opportunity, the window before we get too committed and we've committed too many resources in here to be able to offer you a refund into that. So we ask that you click the button here to just agree and acknowledge that, hey, we're all playing by the same rules, and these are what the rules are that we're going to play together in terms of how we're going to partner. So I think next you click submit.
If I hit submit, it's going to submit it. And if I wanted to make any changes, I would just do this back button. It would take me back and I could make any changes.
Yeah.
Okay, great. So I'll just hit submit.
Yeah. And then submit.
And look at that.
That's your record to say now you've completed the estate planning questionnaire. So fantastic. Well done, Gina. I hope that everybody was able to learn today about how to successfully submit that questionnaire. If you have any remaining questionnaires, please go ahead and work on submitting those now while you have this top of mind and you're in the flow of submitting your questionnaires. It's going to be easiest for you to do it through that way. If you have any questions about the questionnaires, the best thing to do is to be able to contact support at royallegalsolutions.com. Let them know what difficulties or challenges you may be having in completing the questionnaire, so that way they can offer you the best support on that. We know for your best experience that you can have with us is done because you have completed an accurate questionnaires. So I ask your assistance in partnering with us to ensure that we're able to complete those questionnaires in a fully accurate and complete way as soon as possible. Now, for me, complete means, do we have the information we need to be able to do the initial delivery of the product? Because we can always go back and modify later. Anything that we need to do, everything is changeable and it's not hard to modify. So let's prioritize actually just getting it done over thinking we need to do it perfect. And our team can be accessed at the support@royallegalsolutions.com email address for any questions that you have to be able to get this completed as soon as possible. So thank you guys so much. Gina, any closing comments before we wrap?
No, it wasn't. I mean, I just think that that was something, I thought it was going to be really hard, but most of those questions I already kind of knew off the top of my head. I mean, I hadn't really thought about this much, but it's good. And I really appreciate the clarification.
Excellent. Cool. Well, thank you guys so much. I hope you join us here with our next onboarding video.